what is an estate plan really? What does it entail?
Okay, well, I've already told you what the state's estate plan is for you, but let's put that aside because that's not what you want. So an estate plan is a legal, so think of it from a legal structure. Okay, well, that doesn't help much. Let's talk about what it consists of. I can tell you general overall, an estate plan is what you do, what legal documents you put into place to make sure that your voice will always be heard, no matter what happens to you. Even if you can't speak, somebody else will speak for you, that your assets are protected and that somebody can manage them in a way that you would if you could, but you can't because you've lost capacity. And upon your death, that you provide for your loved ones, for your spouse, for your kids, for your pets, and that you don't pay unnecessary taxes. You know, everything that, if you're looking at an ideal world, well, that's what an estate plan can do for you. So let me break it down a little bit. What needs to be in an estate plan? I believe the most important documents you need are your durable powers of attorney. The durable powers of attorney are the documents that you sign that says, if I can't make decisions, well, then I'm going to count on my husband to be making those decisions for me, or my daughter, or my son, or somebody that I trust to make really good decisions for me because I can't. I need somebody to step into my shoes and do that. They have a fiduciary obligation to carry out my wishes, and I know them, I trust them, and so I give them authority to do what I would do. If you heard me say my husband, you might think, well, I'm married. Why would I need to give my spouse any authority? He's already on the joint checking account or this or that. Well, it comes as a surprise to people that your spouse is not legally authorized to do a lot of stuff for you. Think about your credit card. Have you ever called on your spouse's credit card and they say, oh, please put the other person on the phone? Or more importantly, what if you had to sell your house, but you can't because you've lost capacity? Your spouse wants to sell the house. You don't have a durable power of attorney. Both names are on the deed. What happens? Court-ordered guardianship if you don't have a durable power of attorney, even though it's because somebody has to have legal authority to sign on your behalf. And without a durable power of attorney for finances, nobody has legal authority. When it comes to durable powers of attorney for health care, the state does have a hierarchy of who can make decisions for you, and that's out of necessity, that they need to have somebody who can speak for you. But why wouldn't you want to appoint the person that you want to speak for you, not what the state hierarchy is? So that's why I say that the durable powers of attorney are the most important of the estate planning documents you can have. They're not the only ones, but I believe that they're the most important ones, and they're essential for any estate plan.
And they're two, to be clear, they are two separate documents, the healthcare power of attorney and the durable power of attorney for finances. They're two separate documents.
They don't have to be, Jan.
Okay.
We at ELG Estate Planning do separate documents. Our documents are very comprehensive, very robust. And so because of that, and because you might want to name somebody who is different to be your financial attorney, in fact, or your healthcare agent, we find it works much better. Now, to be legally acceptable, do they have to be two separate documents? No, you can find a 2-page durable power of attorney that speaks to both finances and health, and it is something that is a legally effective, a legally accepted document. Whether or not it's effective depends on what you're trying to do with it. So and how do you know? That's why talking to somebody who would be familiar with, well, how would this document work? Talk to the lawyer about, well, why do you have a 12 or 15-page financial power of attorney and a similar healthcare? Why do you have all that language in there? There's a reason for all the language in these documents. What those reasons are, that's where the attorney comes in to explain, well, this is why you would want this particular provision. For example, in our financial powers of attorney, we include gifting authority for Medicaid qualification purposes. Well, why do we do that? Well, frankly, we understand long-term care, we understand Medicaid benefits, Medicaid rules, and you had mentioned something about Medicaid spend down. Not necessarily so. When you work with an elder law firm such as ours, we understand Medicaid asset preservation strategies. So many times we help clients keep all of their assets, no spend down, yet qualify for Medicaid. That's why we will have certain provisions in our powers of attorney that other estate planning lawyers won't have because of their lack of familiarity with the Medicaid program.
So the durable powers, well, the powers of attorney that covers your health care and that covers your finances are very critical documents. Someone in the chat also mentions a PULST document. You know what that is, the physician's order for life-sustaining treatment, I believe.